Welcome to Litigation and Capital.
Hello, everyone, and welcome back to Litigation and Capital with Stephen Mirsky. Stephen is the founder of Mirsky Corporate Advisors, and in each episode, he breaks down high-stakes legal issues affecting companies like yours, those earning 10 to 100 million a year. So you can turn complexity into leverage and protect what you've worked hard to build. My name's Sean O'Connor, and today we're talking about unconscionability. Stephen's going to explain how courts apply it in commercial cases, even when both parties are sophisticated. Stephen, good to see you.
Likewise, nice to see you.
So in commercial disputes, how do courts distinguish between procedural and substantive unconscionability when evaluating high dollar agreements?
Going out with it out of the gates, huh?
Yeah,
so here we go. This is what we're going to do. So, all right, what is unconscionability? Basically means it's really not fair. And I would argue it's super unfair, right? The court just puts different labels on it. And for something to be super unfair, it needs to have substantive unconscionability and procedural unconscionability. Substantive unconscionability is where there's something that the terms are overly harsh or unduly oppressive or unfairly one-sided or so one-sided as to shock the conscience, right?
Got it.
That means like super.
And this is like what's in the contract as the contract.
Exactly. Like if you breach it, I get to steal your son. They're just absolutely horrible. Procedural unconscionability is, were there unequal bargaining position? Mm-hmm. Is the font super small? Does the counterpart, like in an employment context, does the counterparty not speak English and this is 96 pages long, right? These are the things that a court will look to. In addition, they'll look to whether or not there was an absence of meaningful choice in the contract. And like generally speaking, there's rarely an absence of meaningful choice. Because like if I wanted to buy a widget from company A, I could also buy that widget from company B. There's nothing that's really restricting my ability to purchase that widget. So unconscionability is a high bar. It's a contract defense to a breach. You can't sue someone for unconscionability. You can defend against their suit of breach of contract based on unconscionability.
What about the scenario when the negotiation process is rushed, or it's structured to obscure key terms? How do judges assess whether procedural unfairness actually occurred?
Again, you're going to look at sort of the hallmark indicia of unconscionability. Is it a contract of adhesion? Are there fine print terms? What were the circumstances giving rise to the contract and the negotiation? Did you have the ability to negotiate? Was the material term buried in template? So let's look at a couple of cases that I've got right now. In one case, a lender had frozen the debtor's income. So they had no money coming in. They had hundreds of thousands of dollars in payments that needed to go out. Payroll was coming due. And they said, hey, I'm not going to do anything unless you sign this deal. And the deal contained terms that required them to waive their rights to A, B, and C. And, it was a very one-sided deal. So, and one of the terms in the contract says your attorney had the ability to negotiate this. So we redlined it to make it much more fair, and they rejected it. My client signed it anyways. Well, is that procedurally unconscionable? They had him by the balls. There was nothing else my guy could do. This contract was signed under duress. Will a court find that to be procedurally unconscionable? We don't know yet. But those are the types of circumstances that come into play when a court's going to evaluate whether or not unconscionability exists.
I'm wondering how courts characterize terms, right, that are they're so one-sided or punitive that they raise substantive unconscionability concerns. Even in a business-to-business deal,
you're going to look at what's the effect of the clause, right? And whether or not something is one-sided is you look at what's the likelihood that this issue would come about, right? In the loan, let's just use loan context because that's what we're talking about. Is it more likely than not that someone was going to miss a payment? And then if someone missed a payment, even though they say that they bear the risk of the transaction, the other side's going to freeze their accounts or hold them in default or sue them in a foreign court. Are those the types of things that are unconscionable? What are some other things? So I guess it's the balance of the likelihood of the trigger being triggered, and then the harshness of the response, right? Oh, because your business slowed down, I'm going to force you into bankruptcy, right? A court's going to look at that a little bit more with circumspection.
So in your litigation matters, what contract structures have indicated that the parties' agreement on paper, didn't reflect a meaningful opportunity to negotiate?
I'd say that more often than not, when you're looking at a settlement agreement, it should be a flag. Obviously, in a settlement agreement, one party's in a position of power and the other party doesn't have as much negotiating leverage. But if there's no ability to negotiate, and there's significant waivers of terms and other things, I think that the likelihood of unconscionability exists.
Yeah.
And it's really about the circumstances in which the contract is formed.
How do judges weigh disclaimers of reliance or sophistication clauses against evidence suggesting the counterparty engineered the terms to avoid scrutiny?
Depends on the judge, which is kind of a lawyer answer and a throwaway answer. But the unfortunately, it just depends on, I think temperament plays into it, right? And I think the circumstances play into it. I think that a judge who is more of the variety that says, oh, well, the party said it and the contract says it, then that's what it says, versus, hey, yeah, I know the contract says this, but what were they really doing? I think that's where the court's going to dig in. And then I would say that when I'm in federal court, and even a lot of state courts, a court will reason through the analysis, right? They have a duty to do so, in my opinion. But the question is, like, how deeply do they reason with the analysis, and how much evidence can you support? And I think, too, that there's going to be skepticism by a court to find unconscionability because, we generally, as a society, want to enforce the contracts. We as a society want parties to freely negotiate because that's good for business, and it's, we want to make that public policy reliable. So I understand some of the competing issues here, but sometimes when we're talking about shocking the conscience, you really have to look at, all right, what's really going on here and what's the real world impact on both parties as it relates to this contract.
Let's talk about high risk financing disputes. How have courts treated situations where the economic reality shows the deal was structured to operate through eventual breach?
I mean, that again goes to evidence, right? We're going to allege that a contract is usurious and that it was likely to breach. But now we have to prove it. And we can prove that through the lender's records. We can look at public records. I have this one case that I dealt with a while back where the counterparty had filed over 2,000 lawsuits in a 24-month period.
Wow.
So I would use that, public record as indicia that the counterparty was more likely than not going to breach that contract, right? Why else would you file 2,000 lawsuits in a 24-month period? So those are the types of things that you're going to want to look at. I don't think the judge itself is going to get into the economic, trying to tell a judge about the time value of money and showing them, or depreciating assets and things like that. I don't really think they're going to want to engage on those factual issues. I think they're going to want to engage more on the legal issues. And so you got to make it more, you have to be compelling. You have to have compelling facts.
How do judges reconcile the doctrine of unconscionability with the expectation that CEOs and businesses can protect themselves in negotiations?
Courts look at that unconscionability is narrow, right? And this is what we've been talking about. Contracts where meaningful consent is lacking in terms of unreasonably favorable need to be addressed at the formation of the contract, not merely because it happened in hindsight. And so they'll look for adhesion, the lack of real negotiation, surprise, terms that go beyond legitimate business needs, and things that materially distort the risk reward of entering into the contract. Like for instance, in one episode we talked about the one case where a party was lent $1 and had to pay back $1.9 million in 60 days.
Mm-hmm.
Let's look at that risk reward. You have a $1 loan or financing, whatever we want to call it, in exchange for an obligation to pay back, seven figures, and all of the debtor's assets are collateralized. Is that a fair deal? Right? I think common sense would say probably not. And I think those are the types of things that the courts are going to look at, and they need to be extreme. Again, this is not unconscionability is not a defense that courts are going to reward frequently.
And I know we're talking, usually here about, businesses of some size, but is there, and again, this probably depends on the judge, but as a company that then, you should have known better, or there's just there's a bias, if you will, against finding that against a CEO or a company?
I wouldn't say that there's a bias. I just say that and I got to do some lawyering here. It's not a bias. It's just that the court has a mandate through existing case law to say like, hey, unconscionability is narrow. You can only find it in very limited cases. And so to the extent that the court is bound by the narrowness of the finding, I think that a sophisticated business party is going to have a harder time proving unconscionability, as opposed to just a bad deal or a deal that went south.
So if you're a CEO, and you're reviewing agreements, which contract features most often lead courts to conclude that a term is unenforceable, despite the party's sophistication?
It's going to turn on the remedies, right? What's the trigger for a default, and what's the remedies that occur after that? Everything else can be negotiated, and I think that there's an element that CEOs need to recognize about themselves. There is a CEO archetype that is prevalent who is deeply involved in negotiations and is a optimist, right? I would argue that optimism is one of the reasons why people can become CEOs. You have to believe that you're going to be doing something better. And sometimes that optimism and the ideation to get a deal done, like the drive to get a deal done, gets in the way of proper analysis. And so I would advise CEOs that are negotiating deals, make sure you have a counterparty or a counterpart in-house or outside of the company that you can rely on to do the fact checking. Someone that can pump a brake to your gas pedal, because where these issues arise is where the CEO says, yes, let's get the deal done, roses are red and everything's going to be hunky-dory, and then sure enough, you're in a dumpster fire and you just didn't realize it.
Yeah, there's that any quarterly earnings or something's coming up, and there's a certain bias for action with the CEO generally, right, to make stuff happen, and I could see how that can lead to I don't know.
And in the $10 to $50 million, $10 to $100 million space, you're still dealing with the original, in most cases, the original founder CEO. Yeah. Right? So this is their idea. This is their baby. This is what they've been doing. They know better more than anything. And well, maybe you need to surround yourself with people that cover your blind spots and have the awareness to identify what your blind spots are. And I think if you put yourself around a team of individuals that can help you do that, you'll find yourself less likely to be in some of the positions of my other clients.
Yeah, that's interesting in terms of the life stage of a company. And you hear about that, the founder being, there's the person who's great for founding and, taking a company to a certain level. And then there's a different personality or skill set that is optimal for growing that company to the next stage, you see in different environments. That's interesting.
Agreed. And when you're around 20 to 50 million in revenue a year, that's where you should start looking for a COO or somebody else to start really managing the day-to-day operations to grow the business, where the CEO can continue to ideate, create, and do what it wants to do. Moving on, but I guess that's for a different discussion.
Yeah. Well, speaking of which, we're going to wrap this one up, and we'll put a pin in that for future conversations. Good to see you.
Likewise.
That's it for today's episode of Litigation and Capital with Stephen Mirsky. To learn more about Stephen and his work at Mirsky Corporate Advisors, visit their website, mirskycorporateadvisors.com. I'm Sean O'Connor. Thanks for listening, and don't forget to, like this episode, leave a review, maybe share a link with a colleague, and we'll talk to you next time. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.